Good afternoon, everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have attorney Natalia presenting for us. If you are unfamiliar with the format of this event, first, Natalia is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or in the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and legal aid is not representing you at this time. Be sure not to reveal personal details about yourself and to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 2 o'clock p.m. With all that being said, I'm going to pass it over to Natalia to get us started.
Thank you, Marissa. As Marissa mentioned, my name is Todd Watkins. I'm an attorney with our Medicaid appeals team, and today we'll be covering Medicaid service denials. I also want to mention that Legal Aid is a statewide nonprofit law firm providing legal assistance to low-income people in order to give equal access to justice and remove legal barriers. And some of our other kind of practice areas are consumer, disaster relief, domestic violence, education, employment, housing, and its functions. Today, like I said, we'll be going over Medicaid service denials. Oh, yes, and let me also mention we will be answering questions at the end, and I'll go back over that more at the end. Like I said, we'll also be happy to answer any Medicaid related questions as well as just not Medicaid service denials. So today, like I said, we'll be going over Medicaid service denials. We'll be talking about commonly used acronym and phrases. Also discussing Medicaid health plans. And like I said, we'll be focusing on kind of the appeals process when a Medicaid service denial is denied. Okay, so as I mentioned, the common kind of acronyms, one of them being ALJ, which it means Administrative Law Judge. Then we also have like FSS, means fee for service, and then PHP, which means prepaid health plan. A lot of that would be the managed care organizations. Then also, LME, as I mentioned, MCO, managed care organizations. LME, MCO, and PHP may be used interchangeably, with Medicaid changing over the last few years. Some of these terms used to have like very specific meanings. Now they kind of mean the same things. It just mostly has to do with kind of like where someone may be living, and like what county they're in. We'll get more into some of those distinctions. And then OAH is North Carolina's Office of Administrating Hearings, and that's where Medicaid service denials, that process which it goes through. Okay. So as I mentioned, Medicaid managed care organizations, these are kind of like the private health plans that kind of facilitate Medicaid insurance. So we have a list of the standard plans. These are Amiri Health, Healthy Blue, which is Blue Shield, United Healthcare, WellCare, Caroline Complete. And then we have our Taylor Plan organizations. Taylor Plan is based on the county in which someone lives, and Taylor Plans cover someone that needs additional services for like mental health, intellectual, and things like that. So we have Alliance, Partners, Trillium, and VIA. So what are the types of Medicaid service denial? So what is a Medicaid service denial? Medicaid service denial is a denial of a complete denial or a partial denial of covered services from Medicaid, including it could be the length of like an authorization period. So that could be the denial of the pre-authorization, and like say like for like a service, typically like an MRI, maybe somebody a child wants braces. So it could be those different things, a procedure, or even possibly medication. And typically in dental and vision service denials are always handled by state Medicaid or DHHS. And those are because those services are what we call being carved out. They aren't included with like the standard NCOs. So if someone's requesting dental or vision services, like eyeglasses, then those would be going straight through the state. It could also be, like I said, a reduction or termination of previously authorized service. Typically, we may see that with like personal care services or like private duty nursing. That's what would be like considered a reduction or termination of previously authorized. Also, if a provider is failing to provide services in a timely fashion, as I mentioned, sometimes, like I said, with PCS, there aren't available people with maybe an agency, and services not being provided, or like DME, which is durable medical equipment, if it's not being provided timely. And then it also is considered a denial of payment for service. Typically, we may see that when someone has been admitted to the hospital for less than a certain time period, like 48 hours or 72 hours, the Medicaid will pay for like an observation period, but may not pay for inpatient services. That would be considered kind of a payment of service denial. A Medicaid service denial is not a denial or reduction of Medicaid coverage in itself. So that's speaking more to like eligibility. Being actually eligible for Medicaid is not considered a Medicaid service denial. That has its own process, and that's what we consider like a Medicaid eligibility decision. So if someone's concerned about them no longer qualifying for full Medicaid, that wouldn't be a Medicaid service denial. It's also important to look at when someone receives a Medicaid service without notice. It's important to see if it's coming from, like I said, a health plan like WellCare, Healthy Blue, and if it doesn't say those, it may say DHHS or CRSA, which is state Medicaid. Okay. So as I mentioned, just to give again the clarification about what an eligibility decision is, this would be a decision by a local county DSS office. Like I said, this is relating to someone's eligibility for full Medicaid to then get a health plan. And so the type of denials would be either at the initial application, um, during a recertification, someone's being terminated, or someone's changing from like full coverage Medicaid benefits to family planning, which only covers family planning services. As I mentioned, Medicaid eligibility decisions, just a quick overview. These, like I said, are handled at the local level. Typically, someone will receive an initial termination notice. It's the form DS8110. It may say benefits are changing or benefits are terminating as a subject line. Someone then has a right to request local hearing within 60 days of the decision. And if they want to keep their full Medicaid benefits while their case is appealing, then they must file that appeal within 10 days to continue those benefits. And then after someone receives the local hearing decision, they have 15 days from that letter to file their appeal. Typically, within the decision, it's going to have the appeal deadline dates. And then from there, like I said, they have a local hearing with the state hearing officer. This is going to be someone that's not associated with the local DSS office. So it'd be a neutral kind of third party. And then they can also request within 10 calendar days from the state hearing office a decision from the chief hearing officer. However, it is not a required step to do that. After a state hearing, someone has the immediate right to file a petition for judicial review in the superior court in a county where the beneficiary resides. However, someone's like in long-term care, that might possibly be where their Medicaid, kind of case, the local office that still has that case, and that must be filed within 30 days of the decision. And it's always highly recommended anytime doing petitions for judicial review to try to seek legal representation, because there are court rules that apply, and non-attorneys are still held to the same standards as attorneys. So it'd be really beneficial to try to get legal representation and help with those. So now getting actually into the server denials appeals process, the process starts with like an initial denial. So like once a prior authorization has been submitted, with the managed care organizations, there's a kind of a step between that and state hearing, which is reconsideration. This can also be called like a peer-to-peer review with like a provider. And then like I said, after the initial denial, someone has the right to appeal for what's called a state hearing, and that's where mediation and then also state hearing with the administrative law judge would take place. Then, as I mentioned, the petition for judicial review. Okay. So throughout this, you will see that the appeal deadlines and just information that pertains specifically to either NC Medicaid Direct. So someone that's dual eligible, so that means if you're receiving Medicare and Medicaid, then you're going to have NC Medicaid Direct. Also, other people also enrolled in NC Medicaid Direct. Like I said, those that will be in red, and that's just noting that those have a separate deadline than the MCO denials, and then MCO will be in like a dark blue, purplish color. And that's just to make a clear distinction, like what deadlines and what's corresponding with which. So as I mentioned, someone has a right of appeal if they don't agree with a denial, a termination, a suspension, or reduction in their Medicaid service. And that is what we call an adverse benefit termination, and that's the Medicaid service denial. Either DHHS, PHP, or the LMEO will make this decision. Like I said, someone has a right to a fair hearing with a LAJ with the Office of Hearing Officers, and also that person has a right to a written notice. And also with that, if someone maybe not be proficient in English, they can have a right to receive that notice in a different language, or have someone call and read out the notice to them, or someone that may be visually impaired to get, like maybe a bigger copy, or again, like I mentioned, someone to read out to them. And those are services someone will want to call, request, and make sure that's on the file with their either DHHS or with their managed care organization. So once someone receives an initial denial, they have 30 days to appeal that denial if they have NC Medicaid Direct, or if it's like a dental or vision service. So if there's notice from CRSA or DHHS, it's going to be that 30-day deadline. And like I said, typically on the first page of the notice, it's going to state the deadline timeframe and the date to file an appeal by. And then with the managed care organizations, like I said, WellCare, Healthy Blue, Partners, Trillium, someone would have 60 days for that denial. And with both, if it's like a reduction or a termination of benefits, or there's an outright suspension of benefits, the person must appeal within 10 days if they want to continue to receive benefits at that current level. Like I said, we often see that with like personal care services. Like I said, someone's getting the 80 hours a month and then reduced to like 60 or 40, they would want to file that appeal within the 10 days if they want to keep getting the 80 while their case is appealing. Okay. So contents of the written notice. The written notice must include the name of the persons whose services are denied or that were changed, why the service was denied and why, if someone's currently receiving the benefits, when will the change take place, a statement that the person can't have their benefits interchanged until kind of the appeal is resolved if they file that within that 10 days. And basically like, the service end date must be after kind of the notice date, things like that. Also must provide how to get in touch with DHHS or the MCO, depending on who is the one denying the service or reducing service. And get more information about why that change or denial or is occurring. Also must include information about how to get in contact with like a legal aid services, so like Legal Aid North Carolina, or like another service provider like CCLA or Disability Rights, if someone needs legal assistance. And it also must include a hearing request form. For each denial decision, there's a specific hearing request form that gets mailed out to be able to appeal for that decision. And then also the provider who requested the service that's denied, or that kind of act, or that was kind of overseeing the service denial, may also should receive a denial notice as well, from the DHHS or MCO. So starting with NC Medicaid Direct, or mentioning DHHS, that's the governing agency over the Medicaid program. So like I said, again, maybe using those interchangeably, or may also just say state Medicaid if someone's dealing directly with the state for their health plan. So as I mentioned, that initial appeal deadline is 30 days from the date of denial. It will state the person has a right to request a state fair hearing before an ALJ. The person can complete the form that's sent in, and they can either mail it or fax it to the 088 addressed on the notice. And then once that's received, the person can also call to mention that they want to file an appeal. And it's highly recommended if you do call to try to follow up by like an email or just make sure. And you definitely want to leave a voicemail. And on that voicemail, just want to state, your name, your Medicaid ID number, and also, what type of service or denials. Like I said, if you're appealing the fact that they denied MRI or they reduced your personal care hours, you want to mention that. And then you also want to mention your best callback number. And like I said, so even if you're not able to reach someone, it's very important to leave the voicemail. That way there's a record that you called on time when you were supposed to. And then once, like I said, OAH receives that, they will send the case to mediation. Mediation is voluntary, and it's typically handled by phone. However, mediation must happen within 25 days after receiving the hearing request form for OAH. So like I said, mediation is voluntary. Someone does not have to participate. However, if a person agrees to participate, they need to make sure that they do attend those hearings. Okay. So now for the managed care organization's appeals. So as I mentioned, at the initial denial, a person will typically have 60 days from that appeal date to ask for what's called reconsideration. You may also hear it called a peer-to-peer. And like what that means is the provider will be able to speak with their kind of peer, another, doctor, nurse, therapist, who kind of review the denial and kind of like work out, maybe there's more information was needed, or maybe to provide some more context, and see if they can get it approved that way. Like I said, there's 60 days. So like I said, either the provider can kind of initiate that or the beneficiary. And then from there, if the denial is upheld by the MCO, the person then has 120 days to file the request for a state hearing. And as I mentioned, both of these notices will contain the kind of the timeline and also include the date of that the appeal must be made by. It will also contain that state fair hearing request form, and the same things kind of apply with what I mentioned. And typically here with mediation, it's going to be held usually within 10 days of receiving the state fair hearing form. Um, like typically once you file that form, within a couple of days, you're going to get a call from the mediator, and they might immediately try to schedule that um, for uh, for a mediation. Okay. So what to do in order to prepare for mediation and prepare for your hearing? You want to start gathering documentation. You want to organize any information that you have, and then any records from like your medical provider regarding your medical need. It will also be important at this time to kind of speak with your provider to see why you got denied. What information that may already be available that they can just provide. And also with this, the beneficiary has the right to request documentation from DHHS or the MCO regarding the information that's contained in the file for the denial. So all the records the provider sent, all the records that DSS already has that they're using, also have the right to receive the clinical coverage policies that DSS or MCO is using to make its decision. And it's like to have a right to either have that, sent by mail or email. Sometimes it's also just shared with the provider. Um, and also, you are able to share documentation regarding medical need for the services. This can be either in a letter or an affidavit from the medical professional. And so, in this case, a medical professional could be a doctor, primary care surgeon, nurse, midwife, dentist, pharmacist, physical therapist, speech therapist, mental therapist, psychiatrist. And like I said, and with that, even if maybe somebody's going to a PCP or a specific specialized surgeon requesting the surgery, someone can also go to another provider that may have knowledge, or maybe a part of that referral for that can also still give their feedback about why they think it's important. So the letter doesn't always have to come from the provider actually requesting the service. And typically, the best witness will be a medical professional. It doesn't mean the beneficiary or like a parent or a guardian or a sibling or a spouse can't also speak to the health issues and concerns. But with these decisions, they are medical based and policy based. So it really is highly recommended that a medical professional be the one providing that information. And also, like I said, someone can talk about what they're experiencing, but you want to put the most weight on the medical documentation. Okay. So mediation, like I said, mediation, there's certain timelines that mediation has to happen in, like, as I mentioned, either that 25 days or the 10 days. But typically it happens in 5 days. Mediation is very quick. But it's okay if someone doesn't have all their documentation. That's not necessarily needed for mediation. It can be very helpful. Mediation is really just a great time to be able to speak with the medical provider, with the MCO or DHS that denied the claim, to find out, maybe what they're looking for, maybe better explain what's already provided in records. Maybe, like I said, something's just missing. Like it's available, it just needs to be provided. So mediation is just a great time to kind of see where everyone's kind of at about the issue. So mediation is considered voluntary and it's considered a confidential process. So just voluntary just means someone's not required to do it. Someone can file their state hearing request and decline to do mediation. It would just go on to the ALJ. And also what it means by confidential process. It means the things that are stated in mediation then couldn't be used like later, like at the OAH or anything like that. The whole point of mediation is to be able to kind of put everything out there, and to see if you can kind of resolve it that way. And then if not, then you would go to the next step. So who typically is going to attend mediation? It would be the beneficiary, or their like representative, like if they have a guardian or they want someone to assist them. It will be the third party neutral mediator. And it may be also be representatives from DHHS or MCOs, like a nurse, doctor, dentist, maybe a covered service. You can also have your witnesses. Typically, an attorney from the MCO or DHHS will not be present for mediation, unless the beneficiary is being represented and they're going to have an attorney that's present. So typically, mediation does typically may happen without attorneys being present. So at the conclusion of the mediation, and also mostly times these are over the phone. Typically, like I said, it's gonna be like a third party organization. They do like conference calls, so like you have a conference call with ID and a password. It's highly recommended to, if they're calling, to make sure that it is a conference call. Because what may happen, they may try to, do like a three-way call and things like that, and that can get kind of hectic when you have to add the different people. So definitely want to ask about, like I said, either dealing with conference call, or sometimes, like I said, they'll do Teams or Zoom. And like I said, if you are going to do that, you want to make sure that you provide to the mediator when they call you, like any witnesses that may also need that information. And at the conclusion of mediation, if the matter is resolved, then the mediator will ask that you and that DHS, HHS, or MCO have agreed. They will then send off a dismissal to OAH. If they state it wasn't resolved, then it goes on to be scheduled with an ALJ. Okay. So in terms of like I said, the after the mediation before the state hearing, the state hearing must happen within 55 days from the request of the state hearing. And this includes the mediation timeline. So some people do like to extend their mediation to like the full 30 days or so. Then that means, your ALJ is not going to happen like within the next 25 days. If you do need more time than that, you are able to request a continuance, and that's just asking for more time to prepare. You'll want to make sure you make that request in writing, so like say you want to send a fax. You can, if you're a part of the e-filing system, you can, send something to the OAH. It is at the ALJ's discretion, that administrative law judge discretion, on whether or not they want to approve the request. It's not automatic. You should include good cause. And so good cause could be, that, like you're trying to wait on providers' documents, or maybe, you've had a death, you're sick. But those are things that you do want to explain and understand that the ALJ does have discretion, and you would want to make that request as soon as possible, or that you're aware of something. Because like I said, the closer it gets to kind of the scheduling date, they may, not be as willing to move those dates. Because like I said, there's a lot of different people that have to, be there. And so it can be kind of hard to kind of reschedule those things last minute. Like I said, however, if it, things do come up, that is understandable. But if it's something that you can kind of foresee, you'll want to do it as soon as possible. And also, as I stated, during that time, you just want to continue to gather documentation and provide additional documentations to DHHS or MCO. Like I said, so throughout this process, you're not bound to whatever documents have always already been provided. You are able to keep adding new records as they become available, or as you get them. And as I mentioned, the continuance is discretion of the ALJ. If they deny your request or they don't answer your request by your hearing date, you should be prepared and attend the hearing. Just not going due to the fact that you need more time is not a good cause reason. The ALJ may just be wanting to speak with you more, just understand about what's going on, what you're in need of, and before making a decision on whether or not to grant that. Okay. So as I mentioned, the state fair hearing is going to be a hearing in front of an administrative law judge. This is a neutral party, like I said, with OAH. They're not someone with like Medicaid. They're someone with the state. Generally, these are held by telephone, as I mentioned, as a conference call. However, someone can request an in-person hearing. However, those hearings do typically take place in Raleigh. So that's something to be aware of. And you'll want to take a look at the notice from OAH about how your hearing will be taking place. Like I said, typically it's going to tell you if it's in person or it's going to provide that conference information. Like I said, the same people typically who attended the mediation will also attend the hearing. So like I said, the beneficiary or their representatives from DHHS, MCO, the nurses, doctors, dentists, the appeals supervisor, then your witnesses, and then at this point, an attorney from the Medicaid, the state Medicaid, or the MCO would also be attending. As I mentioned, if you want other individuals or witnesses to testify on your behalf, you'll want to make sure you provide their names and contact information to OAH prior to the hearing to make sure that they have it. They should already be ready and prepared for the hearing. Also people do work. Providers might be doing things and things like that. So you just want to let the ALJ, know at the beginning of the hearing, like, hey, this person does want to testify, but they may be doing something. However, they said they'll be by their phone. And if you can let me know when you think, they might be, speaking, I can, go ahead and give them a text, give them a call now, just make sure that they're ready and prepared. So something you definitely want to, mention, prior or even at, like I said, the beginning of the hearing. That way, the ALJ isn't just like waiting around and they can kind of, schedule who needs to speak first and now for those types of things. Okay. Okay, so the ALJ is required to review all evidence that's submitted after the initial decision. Like I said, as I mentioned, yes, you are allowed to provide information after the fact. Do know that the rules of evidence, and these are like state rules, apply. The ALJ does have discretion to admit evidence under certain exceptions. So certain rules of evidence. If anybody watches like court TV, if you talk about like hearsay, things like that, those would be those things. And then when it comes down to the burden of proof, all that means is who carries the burden or who is the person that has to make their case and prove their case. Who has to provide the evidence to support why they think something happened. So if the service denial was for a request for service, it's on the beneficiary and their provider to show that their service is medically necessary and it meets those requirements. If it's a reduction or termination of service, like as I mentioned, a reduction in PCS hours, it's on the state to show why a person no longer qualifies or no longer needs those services they were previously getting. The burden standard is what's called a preponderance of evidence, and that means more likely than not. A more simple way to think about it is like you have to have kind of 51% of the evidence on your side, and this is typically the standard of proof for civil cases. So practical tips for the hearing. It is recommended that you do submit your evidence at least 5 business days for the hearing, and that way the DHHS and the MCO have time to review the evidence, but also the ALJ. Because like I said, if you end up dumping like 30 documents on the day of the hearing, then people won't have time to review that. I mean, obviously, if it's like one thing, especially if you're giving notice like, hey, I'm waiting on this since I get, I'm gonna send it, that's different. But if you're gonna just provide a whole bunch of documents day of. Most likely those won't be able to get reviewed, and like I said, it's going to have that hearing get moved. So definitely just want to be forthcoming about evidence. Like I said, it is possible that you may end up providing documents on the day of. But if you are aware that you're kind of awaiting things, you just want to go ahead and make it known. That way they can also kind of figure it out from there. Um, and typically with that, usually the first scheduled hearing with the ALJ, the judge that usually does these, they usually treat the first one kind of as like a what we call a soft hearing or like an informal settlement conference. 'Cause like I said, depending on when this is being scheduled, it could be a couple weeks, a month, after the initial mediation. So this just provides another opportunity to see if the sides can come to a resolution. How and and then from there they may schedule the actual hearing and then give kind of a deadline on when evidence must be um, provided. But also be aware that this first hearing date may also be the hearing. They may do the informal conference and then immediately go into the actual hearing. So you do want to be prepared for that. And also be aware that if someone submits evidence kind of very close to the hearing, DHHS and MCO by law have the right to ask for a continuance after 15 days. And why that can be important, like I said, with those deadlines, the 55 days, that's to protect the beneficiary. But like I said, if evidence provided at the fact they are able to get that extension by law. It's not up to the discretion of ALJ. They are entitled to receive that. And also in the meantime, the DHHS, MCL, and the beneficiary, they can come to an agreement, and they can maybe the DHHS can change their mind and they approve it. It is possible. They don't necessarily have to wait until the state hearing if they want to change their decision. And then from there, obviously, both sides just need to consent to dismissal of the appeal. So kind of conduct that should occur while in the hearing. You want to make sure that you're addressing the judge as your honor and judge, address any of the attorneys or people associated with the DHHS ratio as Miss or Mr. In their last name. It's important, especially when you're on a telephone hearing, that you're not talking over other people. Make sure that people are finishing their statements, because, like I said, it can be a lot with conference calls. And then big thing is when someone's like testifying, maybe it's a provider, maybe it's the attorney. Even if you don't agree with what they're stating, you don't think it's right, you never want to interrupt their testimony. And also, if you are kind of, then going to ask them questions, you don't want to state, oh, you're lying, you're a liar. You would just want to point out why that their testimony may not be correct. There may be more to it. And that's just really big. The ALJ, can figure out if someone's lying. That's their kind of decision to kind of make. So it isn't a good situation with the ALJ. It's just to be calling a witness or an attorney a liar. And it's also just important, that these things can be kind of emotional. People need services and things like that. But it's just really important to also not get too emotional or flustered or frustrated. And like I said, not be wanting to yell and not being able to control that. However, obviously, if you are getting emotional, things are getting high, you can always act like, hey, like, I just need a second, I just need a break. Would you be willing to provide that? And like, a lot of times the ALJ may be willing to do that. But you just want to make sure that you're not, being disruptive to the hearing. Like I said, with the telephones, just want to make sure that you're muted while someone's speaking. If you're going to be talking to other people, and make sure that's not interrupting the hearing. And also, if you are going to attend in person, please be aware when you're talking to the judge, you do want to stand. However, if you're unable to stand for any reason or can't stand for long, you just want to ask the judge, like, hey, is it okay if I sit down during this? And also, if you're going to try to move from like the table where you're standing or the podium, you'll make sure you ask the judge for permission before, walking across and handing that. And if you do need any type of assistance, maybe you need like, help with hearing or anything like that, you'll definitely make sure you speak to the judge about that prior to the hearing. I'm sorry, at the time of the hearing, if you need that additional assistance and see what's available. Okay. So after the hearing, the ALJ will make a decision. This can either be they uphold it, they uphold the denial, they reverse the denial, or they change parts of the denial. This may mean like maybe someone's trying to get 80 hours went from 80 hours to like 40 hours PCS, maybe they agree with 60 hours. Or there can be when multiple services or like procedures are requested, they may have approved one or two of those with the prior denial, which is for all of them. Or maybe also get into some other things like with medication and things like that. This will be based on documents that were submitted, at the hearing and after. Also, the ALJ may allow time after the hearing for parties to still provide records. Um, but the decision must be made within 20 days of the closing of the record. And as I mentioned, the closing of the record is going to be dependent on if parties request, transcripts, or want to submit decisions, or like I said, maybe we're waiting on additional documents that have now come in. You may request to be able to like submit those. And so once like I said, the ALJ will make a like a deadline for when like they call what we call like at the closing of the record, when nothing else can be provided in order for them to make their decision. And so that decision then is required within 20 days from the closing of the record. And this is considered a final decision. Why that is important, because typically you must have a final decision before you have the right to appeal for judicial review. And as I mentioned, in this, meantime, maybe again the parties have come to some type of agreement. Like I said, that additional information that's been provided, it kind of changes things. It is possible. Okay. So as I mentioned, after the ALJ makes their decision, if either side does not agree, then you can file what's called a petition for judicial review. That will be in the Superior Court where the beneficiary resides. And this can be a little more weird if someone's like in a long-term care, because like I said, their Medicaid case may be still with another county. And this must be filed within 30 days after the service of the ALJ decision. It may be possible that they include that date in the decision notice. However, someone is still bound to know their 30 days and be required to make sure they uphold that. As I stated previously, it's highly recommended to have a legal representation, because even non-attorneys are still bound by the rules of procedure, the civil rules of procedure, and also the court rules for superior court. And that means like when a petition is filed, there's certain things, way the document has to be styled, certain information that has to be included. A non-attorney is still, like I said, bound to the attorney standard. They may get, some leeway, and what I mean by that, maybe, like if they have enough context, they may give them time to accept it and just fix it. But just do be aware, that kind of having ignorance of the rules may not, help you if you miss certain deadlines and other things like that. It's important to include in the petition that, why you disagree with the decision, what's kind of the procedural history of what happened up to the case at this point. So, like including like the provider sent the denial request, the request was denied, this is why it was stated why denial, you did mediation, you did the ALJ. This is also what was denied. And like I said, it may be important, um, and then what you want the Superior Court to do for you. So what outcome do you want? And what it means by why you disagree with the decision. Again, you are able to state, like I said, your opinion, but your opinion needs to be based on, like I said, the clinical cover policy. What are the requirements to meet it? You just don't want to say like, well, I don't think it's fair. It's not right. You want to include some type of legal basis for why it's not correct. And as I stated, you must comply with the rules of procedure, North Carolina Superior Court rules, and also certain counties have their own local rules that you want to make sure that you apply, do. So some helpful links that are on the page are the Medicaid clinical coverage policies. Medicaid does have specific services that are covered and not covered. And so those clinical cover policies are what all the MCOs will use. However, MCOs are able to like provide or pay for services that aren't necessarily covered by Medicaid. These are kind of what we would call the floor, and it's just what the minimum has to be required. But like I said, each different, MCO may, they may pay for additional services or include additional services. Also on the OAH website, it has information about the appeals process, and other information have also included the info for the administrative office, their number and mailing address. And then also the number for ombudsman. Anyone who's having like an issue with service denial or like their MCO, they are able to call ombudsman at 1-877-201-375 for those types of assistance. But and like I said, today we did this listen and learn on Medicaid. However, Legal Aid does offer some other clinics and listen and learn. But I will let Marissa maybe say that because I need to make sure I know the ones we're currently still doing. I kind of this is an older slide, so I just make sure I'm not giving the incorrect information. And then we do have more information, like I said, about Ombudsman here with their, like I said, phone number, their email, and the website. They are available Monday through Friday, 8 to 5. And they do also have Spanish Ombudsman people for those who are Spanish speaking. But and then numbers for kind of like legal aid. So our number is 866-219-5262. And then also have contained the North Carolina Lawyer Referral Service. These are legal aid is not involved with the North Carolina Lawyer Referral Service. This is a service provided by the state bar. These are private attorneys who have not say volunteered, who will offer a 30-minute phone consultation for $50. And you can either call or go on the website, and they kind of have different drop downs depending on what the issue is. So if there's an issue that's not either something legal aid assists with, or if someone's over income, that could just be really helpful, especially if someone just needs some questions answered. But so now we come to the time of questions. I know Marissa has already like mentioned this, so I'm happy to answer any type of general questions about Medicaid. I know today we talked about service denials, but I am happy to answer any like eligibility questions and things regarding that nature. And if I'm not able to answer it, I'll just let you know. But it's highly important that your questions are general. They should not be specific. And the best way to know that if you're providing a lot of context in your question, it's probably not a general question. This is just kind of give legal information. I can't give specific legal advice. So I will, if will give the best answer I can, but depending on how much you provide, I may not be able to answer that. To just be aware. So I'll open the floor for questions, but I'll let Marissa add anything if I've missed it.
Nope, that was perfect. So if you have a question, you either need to type it in the Q&A box on Zoom or put it in the comment section on Facebook. You cannot unmute in this forum. So if you have a question, it needs to be put in one of the chat boxes. Go back to Facebook real quick. Okay, yeah, I am not seeing any questions at the moment, but I am going to give it just a few moments here in case any questions do come in. I did put in the link in the chat a link to the NC Medicaid Ombudsman that Natalia mentioned. So just gonna wait just a few moments here to see if any questions do come in. To those asking, the you will be able to watch this video recording immediately as soon as the session ends. So it will be available to watch later. But as I am not seeing any questions, I'm going to go ahead and say any other questions. Say thank you to all of you for joining us, with a special thank you to Natalia for presenting. Again, if you would like to review anything that was discussed today, a copy of today's recording will be put on our Facebook page. It will be immediately available and can be accessed with or without a Facebook account for about 30 days. If you want to watch the recording later, it will be available on Legal Aid of North Carolina's website. If you would like to register for one of our other listen and learns, such as child custody, tenant rights, fair housing, you can do so on our website at www.legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a wonderful rest of their day.